proceed now. I'll begin by telling you that my name is Dale Nathan. I am from the Twin Cities of Minneapolis, St. Paul, Minnesota, famous for falling bridges, among other things. The first point I would like to make is to tell you about a handout that I believe will be tremendously impressive for you. I represent to you that this handout will explain why judges commit injustices and why they misbehave. This handout is 5 pages long, and I have put a quantity of these 5-page handouts on that table right there. The article, the original article, is 70 pages long. It is written by a law professor named David Barnheiser. In his article, Mr. Barnheiser gives you a whole new perspective on why judges act as they do. And by the time you finish his article, you really understand two things. Why judges are so corrupt, at least a great many of them, and number two, what we can do about that. The original article is written by a law professor like a law professor. It may as well be in Greek in many respects. So I undertook to rewrite it, and I did. I rewrote it into a 30-page summary, which I have. And then I rewrote that into a 5-page summary. I ran down by Professor Barnheiser, and he approved of them as rewritten. I offer this with my representation that it will open your mind to a new perspective about judges. Secondly, I want to tell you in about a minute or two about my personal experience, because it will give you some background. I see that Caroline Douglas is not in the room, but we do share some things in common. In my particular case, in the year 2000, I was ordered by a judge to tell him what my client had told me. In other words, to breach the attorney-client privilege. The case involved a 4-year-old girl who was being abused in pretty bad ways by her biological father, who was not married to her biological mother. Despite evidence of this abuse, rather serious, by a child psychologist, they're highly reputable, the judge insisted that he didn't want to hear any of that evidence. He'd made up his mind. This 4-year-old girl would spend weekends unsupervised with her biological father. After the judge ordered the mother to produce the child for that visitation or go to jail, the mother went into hiding. I did not know where the mother was. I didn't want to know where the mother was. As the proceedings went forward, the judge eventually ordered me to tell him where the mother and child were. And I said very honestly, I don't know. And then he said to me, tell me what your client told you in your last conversations. And I said, Judge, I can't do that. And then he said, well, if you don't tell me, you're going to jail. And I said, well, Judge, I will have to go to jail. He ordered me to report to jail 2 days later. Well, I reported to the jail 2 days later, and I went up to the jailer and I said, I am here to go to jail. And the jailer looked at me and he said, you can't come in. I said, what do you mean I can't come in? The judge ordered me to go to jail. And the jailer said, but I have no paperwork. I said, well, I'll tell you what. I brought a copy of the judge's order, which I had. And I said, here's the judge's order. He said, okay, you can come in. So I went to jail. I thought I'd be there a day or two. Almost 7 weeks later, is when I was released. After they concluded that no matter what they did, I was not going to reveal what my client told me. But that wasn't enough. They started disciplinary proceedings, and the day before Thanksgiving in 2003, they suspended my license with an opportunity to reapply, or to apply in 6 months for reinstatement, subject to 2 conditions. One, I should tell them I was wrong and I apologize. And number 2, I had to take an oath that I would never again disobey any court order, no matter what it was. And I said, no, I can't do that. And so beginning in 2004, I wrote a book. This is my book. It's entitled Minnesota Injustice, True Court Horror Cases. And believe me, they are mind-boggling. And they're the tip of the iceberg. Many of you here could share experiences of court horror cases. Part 2 of the book explains why our system is so corrupt. And part 3 of the book tells what we can do to change our system. Professor Barnheiser, in the article I just mentioned, does much the same thing. And Mark, who preceded me, also had some outstanding ideas on how we can change our system for the better. What I'm going to do now, in the space of a relatively few minutes, because I am watching the time, is to address the subject I was assigned, which is finding evidence of judicial misconduct outside of the record, how we can do that. What is the law? Mark has touched on that extensively. I will add a few comments. What can you do if you find judicial misconduct? And third, I'm going to add to the impressive list that Mark has already given some ideas of my own on how we can change our system. And I do want to tell you, I believe sincerely that I have had some success in Minnesota with town meetings, and I want to tell you about that. I've talked to Mark about that, and I think we share some very good ideas on how all of us here can get down to the grassroots level and help change the judicial system in our country. Believe it or not, those of us in this room can do that. I'm going to begin my comments by reference to the case of Stumpf, S-T-U-M-P-F, v. Sparkman. That's a 1978, less than 30 years ago, United States Supreme Court case that established the rule of judicial immunity. Think about that. Less than 30 years since the U.S. Supreme Court formally established that rule. What does it mean, judicial immunity, as announced in the Stumpf v. Sparkman case? It means that judges are absolutely immune from suits for damages. Suits for damages. And no matter what the judge does, even intentionally, even wrongfully, according to that decision, which was a split decision, the judge is absolutely immune from liability for damages. That case involved a 15-year-old retarded girl who was the subject of a court proceeding brought by her mother and others to have her sterilized. She was not told that. She was told the operation was to remove her appendix. The judge clearly violated her rights, and she was, in fact, removed to a hospital, and she was sterilized. When she discovered later, after she had married, that she could not bear children, she brought a suit against her mother, the doctors and others, and the judge for damages. The U.S. Supreme Court decided no matter what the judge does, even intentionally, if he were to jail you wrongfully, he is immune from suits for damages. A subsequent case decided that the victim could not maintain a suit for conspiracy against the co-perpetrators, her mother and the doctors, and that too fell by the wayside. She had no remedy for damages. However, that does not mean that the judge is immune from consequences, because the judge still is liable theoretically for criminal prosecution. If, as Mark said, you can find evidence of a bribe, a conspiracy, or other criminal conduct, yes, you can bring an action, not you personally, but you can hopefully get an action brought that would punish the judge in a criminal manner, so there is no liability there. And that's illustrated by the case of Roofing Company versus Universal Oil, where a judge in fact took bribes. Unfortunately for the judge, the victim of the bribe was Standard Oil Company. You don't want to fool around with Standard Oil Company. And so after they did their investigations and the like and demonstrated the bribes, the judge was financially destitute. This was in the Depression era. The matter went to eventually the U.S. Supreme Court, and the judgments against Standard Oil, actually its subsidiary, were vacated because of the fraud of the judge, and the judge, in fact, was punished. So there's a clear distinction between judicial immunity for liability for damages on one hand, and the theoretical remedy for criminal misconduct. There's another case I want to bring to your attention, however, that shows you how difficult it is. It is called Cameron v. Seitz, S-E-I-T-Z. It is discussed in my book. Now, this is a case that will pull at your heartstrings, I'm sure, because it does involve some romance. This is the case of a 55-year-old probate court judge who fell in love with his young divorcee secretary, who had no interest in it, but that didn't matter to the judge. He showered her with gifts. Now, don't ask me why he sent emails telling her of his affection. You'd think he could go and talk to her, but no, he sent an email. And that wasn't enough, though, because this young divorcee had the misfortune of falling in love with a youth counselor. This was in Michigan. And they dated, which really angered the probate court judge. And he sent her emails, and he told her, "This is terrible. You shouldn't be dating this man." In fact, I call it the story of the pregnant hill ache. And that's because the probate court eventually sent her an email. And he told her, "I took you from being a pregnant hill ache and made you into the lady you are today." He told her he was thinking of divorcing his wife and other kinds of love messages, whatever you want. Then he started harassing her fiancé and ruling against him or causing others to rule against him. Well, this got to the point where the young divorcee said, "That's it. I have to quit this job," and she did. She took a lesser paying job, and she and her fiancé sued the judge for harassment. They went before a federal jury in Michigan, and they won a huge sum of money, including their attorney's fees. Now, was this judge violating the law? Well, of course he was. Was he harassing her? Of course he was. Did he interfere with her employment? Of course. Did he interfere with her fiancé's employment? Obviously. Well, the case went up on appeal, and of course you can already guess what happened. The federal appeals court said, "You lose. Absolute immunity. The judge is absolutely immune. Nothing he did on the bench, nothing in jurisdiction, but he was a judge, and he was immune." Does that tell you the practicality of going after judges? We come to a third case, and this illustrates my topic. What can you do? You suspect judicial misconduct. What can you do? Where can you get the evidence? This is the case of Minnesota v. Blodgett. You have not heard of this case. It is in my book. I gave it the title, The Godzilla Conspiracy. Mr. Blodgett was a very successful rare coin dealer. He was too successful. He was investigated by the Federal Trade Commission for allegedly misvaluing the coins he was selling. The FTC conducted an investigation, and they found he was clean. No violations of any law. He was clear. Now comes the incredible part. In connection or in conjunction with the civil action that the FTC brought against Mr. Blodgett, they started a criminal action alleging the very same offenses. Now think about that. In the civil action, the government agreed and put it in a court record in the judgment that Mr. Blodgett and his company had done nothing wrong. In the criminal action, the federal government pursued the very same charges. They had cleared him up. There was collusion, open collusion, between the U.S. attorney, assistant U.S. attorney, now a federal judge, and the lawyers for Mr. Blodgett, who had stolen millions of dollars from him, and the trustee, he had gone into bankruptcy, who had stolen millions of dollars from Mr. Blodgett. And so there was an urgent need for the members of the employees of the FTC, Mr. Blodgett's lawyers, the assistant U.S. attorney, to cover up what they had done. So Mr. Blodgett wound up in federal court 3 weeks before trial. By now he was smart. And he went to the judge and he said, "Your Honor, my lawyers are crooked. I want new judges." Guess what the judge said? "You're stuck. You're stuck with the lawyers you have now." Mr. Blodgett was not allowed to testify on his own behalf or tell the jury that I've been cleared of the charges that have been brought against me. His lawyers would not call the witnesses that could have established this. They would not allow the jury to know the truth. Mr. Blodgett and his wife Diane lost everything. He spent 5 years in prison, and he has been the subject of more than one assassination attempt to keep him quiet. Now today, Mr. Blodgett is an example of a person who will not quit. He's still fighting that case 15 years later. And this coming week, because a law professor gratuitously took up his case, there was scheduled to be a major expose in Minnesota involving 4 judges, 2 of whom are sitting federal judges, deeply involved in the corruption, the fraud, all of it backed up by documentary public record. And Mr. Blodgett and his team, I'm not on the team, hope that somehow there will be a public disclosure of this $40 million fraud. I hope he's right, but I have learned, and I'm sure others of you have, that getting the media to pay attention or getting something exposed, especially when there are so many careers at stake, that's a huge undertaking. So I got my fingers crossed. I don't mind telling you, I took out my voodoo dolls and I cast all the spells, and I'm hoping, but I cannot say with certainty that something is going to happen. Now, yes, Mark and also Zena alluded to 18 U.S.C. 242. Makes it an offense for a judge or other government official under color of law to deprive a person of his or her rights. But you have to prove that. And by the way, it's not a crime for a judge to violate the rules of procedure. It's not a crime for a judge to ignore the evidence. It's not a crime for the judge to engage in other misconduct, such as issue a ruling contrary to law. Oh yes, it's certainly misbehavior, but converting that into something actionable is quite different. Well, how did Mr. Blodgett come up with the evidence of the conspiracy against him, of the secret meetings between the assistant U.S. attorney and his own lawyers of depositions that were not made known. He used his companion's civil action for discovery, and in that manner, with the help of a lot of attorneys, whom he could not pay, of course, they uncovered the evidence of the fraud. So here's one answer. If you suspect that there's collusion or fraud involved in a case that you're in, possibly you can use discovery in a companion case to uncover the evidence of judicial misconduct. There still remains the challenge, even if you produce that evidence, of getting some meaningful action. And I do not offer much hope. So where does our hope lie? And that gets me into the final part of my comments. Obviously, we need major change in our country. But saying that as a general proposition is one thing, reducing it to specifics is another. First, we must realize, and I think we all do, that the judiciary, and by the way, the prosecutors as well, are not capable of policing themselves. We're fooling ourselves if we think that judges will reform the abuses. That won't happen. There has to be judicial oversight and judicial accountability, and it must be independently administered. Now, in Minnesota, we have a bill in our legislature to set up a legislative agency in the nature of the General Accountability Office. We're calling it the Judicial Accountability Office, that has the power to investigate alleged judicial misconduct. Notice it is independent of the judiciary. Secondly, we, Mark, Caroline, Zena, Michael, and others, must draft the reform legislation. If we leave it to legislators, however sincere they may be, to draft meaningful reform legislation, it probably will not happen. They don't have those kinds of talents. They don't have that kind of time. By the way, many legislators, I will be giving testimony next Wednesday, as I'm scheduled to, before the Minnesota Senate Judiciary Committee. I cannot tell you how excited I am about that. And I know they want to do something. They really do. Not all of them, but enough of them feel the pain of the people. Now, the head of this particular committee is named Mi Mua. She is the only Hmong senator in our Minnesota Senate, and she has a perspective that is for the people. We have some hope. But she needs help. She needs help in two ways. She needs draft legislation. I'm going to provide that to her. And she needs grassroots support. And I'm going to talk about that in a minute. We must organize far better than we have up to now in energizing people. Now, this conference, it's a great start. But you know what? I'm going to tell you that when we start talking like lawyers and legalities, how well do you think we connect with the grassroots? We don't. We have to find ways, and I've been talking to Mark about that, and also Byron as well, about how we can communicate with the grassroots. And that brings me to town meetings. In Minnesota, my group has conducted 32 meetings so far around the state. We've taken some excerpts from a very good movie, Aaron Russo's movie. We've entertained our audiences, so to speak, and we've engaged them in understanding some of the abuses that are happening in their language. And they have filled out petitions, and they have filled out postcards, and they have taken the telephone numbers and the email addresses we have given them, and they have communicated with state legislators saying, we, the people, want change. And if we can organize that on a scale around the country, so that each of us here are out there energizing the people who know the problem, who are asking for help in what to do. If we can do that, we can cause them to express their sentiments to their legislators and build a momentum to support the kinds of reforms that we're talking about. We need a group of influential leaders to help spearhead our effort, and we have some of them even here. I was very moved by the Reverend's remarks last night, and he is an example of the kind of leader, the strong voice that we need to bring our message to the people and to energize them and to get the respect and the notice we need from our leaders. Here's something that we need. I think you may disagree. We need products. We need DVDs. We need other kinds of materials, like my book, if I may say so, like Caroline's book, products to sell to the people that speak their language, because they will spend up. I've sold Aaron Russo's movie. I shouldn't admit this. I'll probably be indicted for something. Now, I bought them for $1 each, and I sell them for $9 each, and people think that's a real bargain, a DVD for $9. Well, you know what? The people like the DVD. They play it. They even play all of it, I think, sometimes. And we make enough money to cover our expenses. We need to have a product line to give the people something that they can take with them and gives us some of the money we need to forward or to further our cause. Obviously, we need to raise some funds, and we're working on that. All of us are. We can't always do everything we want if we don't have the monies that we need. And last, we need a body of agitators, people who sincerely believe in the reforms we're talking about, and will speak of them every chance they get. I want to conclude by saying that I cannot tell you how grateful I am to Zena and Rod and others for the opportunity to participate in what I think is a most meaningful conference. I know I'm among, I'm going to say, certainly friends, and in some cases some co-victims. And of course, misery does from time to time love some company. More than anything else, I am inspired that after 4 very long years for me, 15 long years for Mike, some long years I know for Mark and for Carolyn, that we still have the strength and the fortitude and the belief in our system that if we work hard enough, we can get the job done. I will commend to you a wonderful movie. How many of you have seen the movie Amazing Grace? Anyone? What did you think of it?
I adored it. I put it on my website. I recommended it.
Do you recommend that others see it?
100%.
I make that 200%. Amazing Grace is the story of William Wilberforce, who persisted for decades to end the slave trade in England. And miracle of miracles, I won't tell you the result. You'll have to see it for yourself. I also recommend a book. It's called Character Counts. It's a 120-page book. The author is Os Guinness, Guisness. It's the story of 4 people who had the strength to persist. It's inspirational. I do have to warn you that if you read it, it could change your life. Be careful. It inspired me to do crazy things. I'm still doing crazy things. But so be it. Thank you very much. Appreciate your attention.